SJC-12846 in the matter of an impounded case.
He's not filming this case, correct? Okay, just make sure he's not, because, I know, but just make sure he's not. Okay. Okay. Wait, Fran, why don't you just double check for one moment?
Just turn it.
Okay. Have you called the case?
I don't need it.
You have. Okay. Mr. Lear, we wish you had somebody on the other side to argue the other side, but we don't. So we will rely upon your fairness in your presentation. You may proceed.
Thank you. Good morning, Chief Justice Gantz, Justices, and may it please the Court. Kathleen Delisle on behalf of the appellant, the father of the minor child. The lower court erred in dismissing this case for lack of jurisdiction, and as a result, this child's legal parentage hangs in limbo and subjecting other children to the same instability.
Were you counsel below by any chance?
I'm
Were
sorry?
you counsel below?
Yes.
Why did the judge do what she did?
I have no idea.
She didn't explain it? There was
No, it was a one-word, one-line dismissal. It's a dismissal for lack of jurisdiction with prejudice.
Yeah, yeah. So there was no oral argument or anything like that?
No, Your Honor.
You have no
And
insight into why she did what she did?
I have no idea, and none of the motions that I had filed had been acted upon. And the docket that's in the record appendix shows that there was no oral arguments, there was no motion session. We were not allowed to be heard. I filed this case 3 times and hit a roadblock every single time.
And the mother lives and gave birth in Massachusetts, right?
Yes, the mother
And,
lives
and
in...
is there any other jurisdiction in the country, even theoretically, that
None.
could?
None.
So your argument is that basically the domicile of the child is the domicile of the mother.
Yes.
And that
And
the
under
mother's
209C10B, that's exactly what it says, is that when you have a child that's born out of wedlock, until a court makes a decision otherwise, the custody is with the mother. So if the custody is with the mother, then the child has to have a residence with the mother. I will admit that this child has 2 residences, one with the mother and one with the father, as many children in the Commonwealth do. Children of divorced parents have 2 residences, but her domicile is with her mother in Weymouth, Massachusetts.
And am I also correct that the residence with the father abroad is only because the mother gave permission?
Correct. The
So
mother
if
had
the-
to give permission for the father to travel.
So if the mother had said, no, I withdraw my permission for this child to be with the father abroad, that the child, as a matter of law, would be required to be returned to the mother.
And the Norfolk Probate and Family Court would have jurisdiction over that matter to return the child to the Commonwealth. So it makes no sense. It's completely illogical that the trial court would not have jurisdiction over the adoption.
And
mean,
it's also, sorry, the mother's trying to surrender her rights, correct?
Correct.
And if this is not permitted, then she is legally obligated to the child in all the ways that a legal parent would be.
Forever, correct.
So I don't mean to oversimplify this, but if there's a child that's born in the United States and there's an issue of adoption, someplace in the United States has to have jurisdiction.
Well,
And I mean, obviously,
Right.
Massachusetts seems the most obvious, but isn't it just someplace has to have jurisdiction over this issue, right?
correct. And Massachusetts is the logical place because the child was born here. And Stern says being born in the Commonwealth is enough to avail yourself of the adoption statutes. And the mother lives here.
And the
mother is still
statute on
here.
jurisdiction suggests that if there's no other place that has jurisdiction, then Massachusetts, if the child's domiciled here, could have jurisdiction.
Correct, if it's in the best interest of the child, which
And
clearly this is.
that's the key point, in the best interest of the child.
Correct.
So, okay.
And I think it's important to point out that the Probate and Family Court, including this court, has Norfolk, has entered a number of adoption decrees with a fact pattern identical to this one for all sorts of different reasons. So the dismissal of this case is arbitrary and capricious.
What are the all sorts of different reasons? What other categories would come into play?
Well, so we have situations where children are born on their own schedule and not on ours, so we would file a pre-birth order of determination petition pursuant to Culleton, and the judgment isn't entered before the birth, and the current position of the Registry of Vital Records is that if the judgment under Culleton is not entered pre-birth, then that matter is moot and needs to be dismissed, and the only remedy is a post-birth adoption. If this court were willing or inclined to clarify that Culleton does allow for post-birth determinations of parentage, that would be more than welcomed.
Counsel, let me ask you, assuming we agree with you, what's the appropriate remedy? Is it for us to enter the order, or is it for us to order the probate court to tell the probate court it has jurisdiction and now proceed with your normal course,
Ideally, to have this court just enter the adoption decree. The elements have been satisfied. But if this court is not so inclined to do that, then the appellant is requesting that you reverse the trial court, order that the adoption petition be reinstated, order that jurisdiction is proper, and then order adoption finalization forthwith. This case was filed when the child was less than 2 months old. This child is going to be 2 years old next month. This child has been hanging in limbo unnecessarily for 2 years.
Is this a common problem, or is this just an odd outlier?
It's a little bit of both. This particular is odd. I was frankly shocked by the course of events. I've never had this happen before in this type of situation. I have had plenty of situations where the probate court does not act quickly enough on the Culleton petitions such that then the cases are dismissed, so then we have to file a post-birth order, which, as this court said in Culleton, leaves these children in limbo until the adoption finalization can be finalized. I know that there's a standing order, 106, that says that if you haven't assented to adoption, the finalization must occur within 30 days of the filing. I've been doing this for 25 years. That has never happened in any probate court in this state. So we're looking at realistically a 6 to 9 month lag time between when the adoption's filed and when the finalization occurs. So much can happen to people in that time period. And as this court recognized in Culleton, it's important to have the children's parentage clarified as soon and as early as possible. And the Commonwealth does the most assisted reproduction cases out of all the 6 New England states combined. Yet the Commonwealth is the only jurisdiction where we can't have another remedy like a post-birth order to clarify the parentage, short of doing an adoption and having such a significant time lag.
Are we behind in legislation, would you
Yes.
say?
Severely.
Which state do you think does the better job on legislation in this area?
Well, Maine and Vermont have adopted the variations of the Uniform Parentage Act. New Hampshire created something of a hybrid, which as a practitioner in New Hampshire, I personally really like because it works really well. Maine and New Hampshire have a few more little hoops to jump through, which causes delays. And New Hampshire is a very streamlined process.
So is it the Uniform Parentage Act that you think we should be adopting?
We're trying desperately to get it adopted in Massachusetts.
Yeah, as a matter of legislation, though.
I'm sorry?
As a matter of legislation, not as a matter of judicial fiat.
Well,
I would welcome this court's adoption of the Uniform Parentage Act.
Has this court ever done what you're asking us to do, which is sort of do it ourselves? Or is it usually done through a remand and instruction to the trial court?
I don't know the answer to that.
But you're not aware of any times where we've actually done this?
No, and I'm not aware of whether you've been asked to do it before either.
If we were to side with the judge, what is the practical consequence?
The mother, who is a citizen of the Commonwealth and also deserves the protections of this court, would forever be the mother of this child with the legal rights and responsibilities forever, contrary to the intent of the parties, which this court has said in part and was important in determining parentage to look to the intent, which is contrary to the AZVZ decision, which says you can't force someone to be a parent. And, you know, it has ramifications on the mother's own children themselves. If she were to die intestate, this child would have the same legal rights to inherit as her own children who are citizens of the Commonwealth. If the father became incapacitated and applied for assistance in Mauritius, and Mauritius found that the child was in need of, you know, they were entitled to public funds, Mauritius could look to this mother for child support, which has happened in Sweden. So it's not, I'm not making and just hypothesizing things. There's a situation in Sweden where they did not finalize the adoption. It was a Maine case. They didn't finalize the adoption in Maine. Father applied for public assistance, and Sweden looked to the mother, the gestational carrier, for child support to reimburse the state.
Mauritius is much more complicated, right? Because
Mauritius is much more.
They're not allowing gay couples to adopt, even if.
Right.
And they're also not allowing, even though this man, one of the men is the biological father, without a biological mother, they can't. On a birth certificate, they're not going to recognize this, right?
Right. So that's why we and I was not the attorney that handled the matching or the gestational carrier part of this. I was called, I don't know, a week before delivery saying, hey, we have an adoption for you. So, but what was clear is that they forego the option of getting a collagen pre-birth order, because if they did, then the dad's name only would go on the birth certificate. Right. And if he went home to Mauritius with only a dad on the birth certificate, the child would not be able to get citizenship, which would affect her education, her health care, employment. It would have lifelong consequences for her. So as practitioners, we need to be very mindful of what the laws are in the home country, because it's never going to be in the best interest of the child to go home and then not be able to get citizenship in their home country.
So out of curiosity, what happens now? Assume we do what you want, and the child becomes adopted by the father. How is that different than what you were just saying? What will her status be in this other country?
Well, because Mauritius, like the United States, is a signatory to the Hague Convention, so the Mauritius would honor the adoption decree here, and it doesn't look to the underlying factors behind it, because it has a Hague signatory country adoption finalized, and by signing on to that convention, the member states are saying we're going to comply and basically certify that this is a valid adoption. And so when it's presented to the officials in Mauritius, that will be the end of it. Mm-hmm. You can be a single parent in Mauritius. You can't be a gay couple parent in Mauritius. So, I mean, you can be a single parent, and that's what he would be in the eyes of Mauritius.
Okay, thank you.
Thank you.